Hello and welcome to yet another episode of Smart Indian Agriculture on the Federal.com. I am Vivian Fernandez. India does not allow the patenting of living organisms, including plants, but processes, artificial gene constructs, or events, that is, the location of an inserted gene in the chromosome of a plant, can be patented under the Indian Patent Act. Parallelly, plant varieties with unique characteristics like high yield or pest or disease resistance or climate resilience can be registered under the Protection of Plant Varieties and Farmers' Rights Act. The law recognizes and protects the rights not only of commercial plant breeders, but also of farmers and farming communities who have conserved, improved, and made available plant genetic resources for development of new plant varieties. The PPVFR Act was enacted in 2001. The regulations were notified in 2006. So far, the PPVFR Authority has issued 5,023 registration certificates. Our guest on this program is Dr. Kumble Vinod Prabhu, Chairman of PPVFR Authority. Dr. Prabhu belongs to coastal Karnataka, a fact that I mentioned because I also happen to be from the same area. He was earlier Joint Director Research of the Indian Agricultural Research Institute, or IARI. Dr. Prabhu also chaired the committee of the Department of Biotechnology that drafted the rules for genome editing. Those rules were notified in May and been critiqued on this program. We will give Dr. Prabhu a chance to respond to that criticism as well later in this interview. Dr. Prabhu, welcome to this program.
Thank you.
Dr. Prabhu, when I interviewed you in April 2018, 2 months after you took over as chairman, you said you wanted farmers' registration certificates to be not just decorative, but profitable as well for them. So far, out of 5,023 registrations, 2,003, or about 40%, have been given to farmers or farming communities. How many of them have been able to actually put these registrations to profitable commercial use?
Obviously, the purpose of getting the varieties protected by farmers or breeders is with the aim of getting the breeder the recognition of ownership of that material, and then anyone who makes use of it for cultivation purposes or seed purposes would give in return to the owner of the material something for which he has spent his time and money and resources. And many farmers have now even licensed. So that's a very, very nice thing to tell the world across, that farmers who have bred the materials, have registered it here, have now got licensed dealers who would produce it or market it or sell it as per their license arrangement, but have licensees, just like any other professional breeding company. That's something that has happened in horticulture field very successfully. In the case of flowers and fruits, it has happened. Quite a few are there who are doing it now.
Because of e-commerce, have these people been able to, sell their varieties on the e-commerce platforms?
E-commerce platform is there or not there as far as varieties is concerned, because varieties cannot go across zone, agroecological situation and the production condition for which the variety is the best. So it cannot be e-marketed beyond the reach. Our act does not deal with the produce from the seed. As long as it is only for seed purpose, we control it. Rest of the things are totally freedom of the market. We have nothing to do with the produce as non-seed or non-propagule.
No, what I'm saying is that once these registration certificates have been given, have the farmers been able to sell the produce as unique products, with unique characteristics to the market as such, to the final consumers?
Obviously, see, this goes hand in hand. If the variety has a feature which attracts the farmer to keep buying it, it will work. So it is not something that can go just because it is registered, it will go. It will be based on the variety's suitability in terms of its commercial returns to the investment any other farmer makes as a harvesting product that comes out of it. When we register, we don't look at the economic value or agronomic suitability, etc. of the variety. We only look at its being genetically uniform and genetically stable. So it should be distinct from existing variety on any other visible traits. It is not about productivity or any special trait it may have for farmer to buy it as a producer of the material. So that is a different aspect. In Indian law, we don't look at the produce aspect, whereas in UPOV, which is other international system that is existing, they have post-harvest related regulatory principles also, which is not possible in countries with small farmers. And that too with myriad of variation of say farm to farm within 1 acre distance, or within a kilometer, you have 10 different farmers growing 10 different crops in India. So it is not possible to do the post-harvest related product. In fact, India is one country where other than basmati rice and mangoes, for example, you hardly have any variety identity-based market. In apple also. In fruits, we have in some cases, but in the major crops, other than basmati rice, and to an extent, Madhya Pradesh wheat, there is hardly any other variety-based selling in the mandi when the farmer goes.
In October 2018, the authority changed the criterion for giving registration for plant varieties and hybrids. It wants the parental material to be provided so the authority can develop its own seeds through third parties and satisfy itself about the claims made before registration is given. The seed industry is very upset, and it has also moved the Delhi High Court. Now, why did you change the criteria?
Okay, since it is in the High Court, as you have mentioned yourself, it would not be fair for me to give an explanation about why it is done, because that is sub judice. So let us not talk about it. But what only thing I have to tell you is what we have done is we have not changed it. What we have done is what had to be done. What was not being done. It is not that we have changed anything. We have done what was not being done, as required to be done by definition, as given in the Act itself. It suffices at this moment.
No, why would a company share proprietary material, and that too with the third party? Because these are all this technical knowledge. No one would want to part with this because there is no guarantee that it will be kept safely.
See, Vivian, if you want to stake a claim that you have some intellectual property on something, either a design or a patent or something, and tell the patenting authority that I will not reveal what is my specialty, but you give me that patent, will it work?
So how about the registration?
I will not tell you anything. It is my trade secret. I will not tell you anything because it may leak. You may leak it to somebody else. I will not give you my design, but give me a patent or registration of the design as unique because it is unique. I am saying it. Will that be okay?
But some 3,000 certificates were given before you took over without this criteria.
See, I think we are getting back into the same rut. I said what we have done is what should have been done. Why it was not done is not the issue to be discussed because it is past. What we have done is what should be done as per the requirement. And as I explained to you, a patent claimant, if he wants to hold the uniqueness of his patent to himself because it gets leaked otherwise, then he will not get it. As simple as that. A claim is not sufficient. It has to be proven to be a claim, isn't it? So that's.
But has the number of applications reduced to a trickle because of that? Because the private companies at least are not coming forward. What I understand is that of the 1,300 applications that have been made after you took over, most are from public sector research institutions or from farmers, and not so many from private companies.
No, it is not so. That number is perfectly okay, but that is not because of any say result related to the changes in October 2018. So since it is sub judice, I would not like to give any details about it, but you must also give leverage to the 2.5 years of COVID related say lack of movement and activity, and these are season based, unlike other say authorities which grant intellectual property. The seed has to come in time for the sowing time. If lost, the entire year is lost. So therefore, applications are now, see, that is another change which we brought in, that we accept the applications within a window for that year for it to be counted year registration period counting. That is, for material to be planted in June, July, we need to get it before March 30th. So if any application that comes after that date will go to the next March 30th. So therefore, that doesn't get counted as the material to be tested this year. So these are the changes we have brought in, which are logical because there's a biological material. So that's the point.
I also
So
understand that the
that we
protection.
introduced.
Yeah, I also understand that the protection is given only to the parents and not to the crosses produced from those parents.
No, that's wrong. That's wrong. The protection is given to both hybrids as well as the parents.
Okay, I stand
individually
corrected.
They can licensee can individually negotiate with each of the two parents, as well as if it is three parent one, it's three parents or two parents, and the hybrid separately for any of the rights to market it or sell it or produce it or multiply it. Any of these rights individually, he can deal with any of these materials, individual parent one, parent two, and hybrid. There is nothing restrictive.
Under the Act, farmers can save, use, sow, resow, exchange, share, and even sell farm produce, including seeds of a protected variety, provided when they sell it, it is not branded or packaged.
Yeah.
Now, what happened was in 2019, some 9 farmers from Gujarat had taken the material of PepsiCo, which is a potato variety FC5, a protected variety. They had developed their own seed and had sold it to a rival, Pepsi's rival. Now the company moved the court and obtained an injunction, but there was so much of outcry from civil society groups. About 190 civil society groups said that a big company was trying to squash some small farmers, and it was bad optics for that company. And the farmers themselves, in defense, said that they had obtained the seed from friends and relatives in a customary and conventional manner. Now, my whole point is that this defeats the very purpose of protection, because under the UPOV, the international treaty, they have objections to what is known as this brown bagging provision of the Indian law. Don't you think that this brown bagging provision actually dilutes the protection that the PPVFR Act gives?
No, that is the purpose of our act. Okay, to help the farmers have their right which they had prior to the coming of this act. That is why we are not part of UPOV. That's the very reason. There's no point in looking at UPOV and comparing with UPOV, because that is why we made an exception of going sui generis, not adopting UPOV as is how is. And plus, there's another bigger issue which I would like to bring it to your notice. The same UPOV countries, without exception, are signatories to the ITPGRFA, International Treaty on Plant Genetic Resources for Agriculture, where these very exact worded points are there in Section 9, which are supposed to be complied with by all these countries. We are the only country globally which has complied with it. And there is a purpose behind it. It is a global understanding of the right the farmers have had in giving you the food and the materials which they have worked hard on as their livelihood. So that should not be curtailed to an extent they become totally on a slave ground to the masters who produce the materials. That is one side of it. The second side of it is that if it were to be the browning of the brown packaging of the seed were to be diluting the right, then it would not have happened in such an extent where I am myself licensed to more than 200 companies, one variety, and have engaged 16,000 farmers prior to that licensing for producing seed and selling. After that, the licenses came to me because of the point that those farmers tested the veracity, tested the applicability, tested the efficacy of the material freely of their own will and their own purpose. And that is how the companies were aware that the variety would do well, and they came forward. This next point I would like to tell is this. This is not dilution. It is an access to the farmer in time when right seed from the right company is not available to him at the place where he can afford to go and buy. That is something we are totally ignoring when we are saying dilution. No company, no seed company, PepsiCo or any other company can reach remotest of villages where potato is being grown. What will the farmer do? He has only half an acre of land. Can it spend 600, 800 rupees to reach a town place where the seed is being sold by licensed seed seller by the PepsiCo? It is not possible. So it is unrealistic to believe that the farmers cannot buy the seed, so therefore they cannot grow that seed. So that is his right. That is one of the rights the farmer has in our act. He is free to grow whichever material he wishes to grow. So therefore, that has to be facilitated because of the large number of farmers in India, and that is how we have it's not possible. Even for PepsiCo, it's not able to cover all the potato growers if all the potato growers wanted to grow their material. There is no way.
Moving on to the genome editing guidelines, in May, geneticist Deepak Pantel, in a Zoom interview on this website, he said that the guidelines were ambiguous and they gave too much power to a university or research company's biosafety committee when it came to deciding when a genome edited plant should move from containment to open fields. He was saying that these guidelines give too much of discretion to the institutional biosafety committee. What is your viewpoint?
Okay, Professor Deepak is a very nice senior colleague and senior friend of mine dealing with the same subject of plant breeding. With all due respect to him, what I would say is the guidelines are regulatory guidelines. They are not guidelines to encourage or to motivate the plant breeders, geneticists to edit their genes or edit their genomic region to produce better material. That is not the purpose. The purpose of the guideline is to regulate when they do that process, to regulate so that nothing escapes uncontrolled, because they have to use non-host or non-native genomic, reagents or genomic components while editing. So that cannot happen without introducing foreign genetic element into it. So when such a thing is being used, when they dispose of unwanted material as a result of their production, just like waste material, that should not go uncontrolled. And how that has to be regulated, it is those features which are covered in the guidelines, not about the making business easy for the genome editing process. That is a skill of genome editing that is different. So I think there was a confusion. The question is just this: if the surgery has to be done under aseptic condition, and that asepticity is to be given by some agency which looks at the regulation of septic conditions or aseptic conditions being maintained, infection-free situation is maintained, the surgeon cannot do that. Okay, and if the surgeon is asked to wipe his hand or wash his hand or wear something, he has to do it. So that is the question. He cannot say my life is becoming difficult because of that.
Life might be becoming difficult because once the foreign genes that are used to do the editing, the genome editing, are removed, why insist on data regarding off-target mutations, for example?
No, we are not asked for. That's wrong. There is nothing like it. Once the product is there, there is no regulation at all. All that the guideline is saying is before you reach to the situation that you have now got a material which is free of genetic, any other foreign genetic material. After that, once you prove it, there is nothing looked for as regulation. So there's a confusion. When you have to have the roti, you have to do all the other preparatory kneading, etc. So instead of looking at how you need it, and when you need it, what is left is what is not left. How that is treated is the point in the guideline, not after the roti is made.
And one final thing, regulations also say that, the developer has to prove that the mutations are stable. Now, why do you insist on that? Because what Dr. Patel is saying is that once the mutation happens, it is going to be stable.
No, he is wrong. It is not that every mutation that happens is stable. The evidence is required that the mutation is stable because of the nature of integration of every editing unit that happens. That's why anybody, one who has done editing, Deepak possibly did not deal with editing himself as a producer of genome editing tool. When you do that at the T0 to T1 stage and T1 to T2 stage, there are a lot of problems in maintaining the integrity of the material because of some remnant reagents still work.
Dr. Prabhu, I'm afraid I have to interrupt you because we are running out of time. Thank you for all those clarifications. Thank you once again.